Is it okay to begin, Your Honor?
No, let's let everyone get settled and get all their materials out. We have plenty of time. Okay, Mr. Fazzio.
Yes, thank you, Your Honor. Anthony Fazzio on behalf of Amy Rose and her minor daughter. This case arises out of a huge explosion in DeRidder, Louisiana. The subject of the explosion was a tank in which, in the paper-making process, turpentine is one of the additives or one of the byproducts of the process.
Mr. Fazzio, we've read the briefs and looked at parts of the record, so we're familiar with the basic facts, so why don't you move to your argument, right. And you can certainly relay the facts to us as it regards your argument.
Thank you. There are only 3 issues before the court. The first issue has to do with the failure to remand this case. I prepared...
That's on the fraudulent joinder issue, is that right? That's in regard to the fraudulent joinder issue.
Yes, Your Honor. I prepared a 25-page petition in which I methodically set out in 151 paragraphs exactly what happened during this explosion. In that petition, I focused on one particular employee, Mike Wallers. Wallers was the superintendent for the recovery tank. And Wallers gave the order for the other employees not to drain the tank. This was an annual shutdown. And during the annual shutdown, what occurs is that any equipment that is broken is repaired. It is publicized across the entire company. And on this particular occasion, welders were needed to patch up a broken line that went not to the recovery boiler, but to another boiler or to a recovery center. And they were working right above the tank that exploded.
Is there any evidence, though, as I understand it, there's not any evidence in the record that Wallers knew about the welding work? He knew about, or may have even directed the issue of whether the tank was going to be drained, but he did not know that welding would be going on next to the tank or near the tank. Is that right or not?
Well, that's certainly what Mr. Waller says. He did say that in his deposition. However, the annual shutdown or the annual repair of machinery is done annually, and it's done throughout the whole process. So,
what did Waller specifically do that makes him liable in this case?
He did the following, Your Honor. Number one, he knew that this was an annual correction of the material that was in disrepair, an annual shutdown. He also knew that during this shutdown, certain equipment would be repaired. This happens every year. Waller knew that on this particular occasion, for the last 28 years, and that was Mr. Flores's deposition, for the last 28 years, those recovery boilers were drained during an annual shutdown. Wallers knew that. Wallers gave the order not to drain the tank, and he was also, in his testimony, he claimed...
Now, if he had drained the tank, the explosion would not have occurred. Is that what you're saying?
Yes.
All right, now, what does Wallace say? Why does he say he did not drain the tank?
He denies ever making the statement to Smith and the other employees. He says he never gave,
Should have been drained?
he denies ever making the statement to the employees not to drain the tank. That in itself creates an issue of fact about this case. And so in Waller's under cross-examination.
Who says that he was told about this event?
Smith and Fogelman. Smith was the person who took the order from Waller's, and Fogelman overheard the conversation between Smith and Waller's and was quite surprised, almost stunned by the fact that this recovery boiler was not drained. It had happened for 28 years, and this is the one occasion that it was not drained. Now, Partridge, who was a co-worker with Waller's, also said that Waller's said after the accident that he should have drained the tank, but he didn't want to do it because it would cost too much money. And the figure of $100,000 is the one that Partridge remembers. So in this particular case, Waller's is the reason the explosion occurred.
Why did the district court then say there was no possibility of recovery against Waller if you had the evidence that he specifically had given instructions not to drain the tank? The failure to drain the tank was the cause of the accident, and he should have drained the tank.
Well,
What did the district court say about that? That's the evidence.
Well, that came up in two ways, Your Honor. One, on the motion to remand, Waller's provided the court with a declaration that implied that he was not at work that day, and therefore he couldn't have given the order. At that point in time, no depositions were taken. This was done at the remand stage. It was only later that we found out through depositions of Flores, Fogelman, and Smith that Waller's actually gave the order by telephone that morning. So the way
Did you refile or re-urge your motion to remand after you obtained the discovery?
No, I didn't, and that's a good point. Judge DeGravelle, in a similar case, Reese versus Ham, had an instance in which a motion to remand had already been decided. In that case, in the Ham case, Judge DeGravelle said that once the court makes a decision on not to remand the case, then they cannot revive or revise that decision. And so looking at the law at that time, there was simply no reason to refile it because the court could go forward even if Waller's wasn't in the case. In other words,
What you're saying is that you did not ask for reconsideration of the earlier ruling based on the newly discovered evidence is because as a matter of law, it would have made no difference.
that's what Judge DeGravelle said in,
What is the authority for that?
well, the judge's ruling in Reese versus Ham.
But there's no case that says that? There's no other kind of indication that would bind that as a matter of law?
But I also think, Your Honor, that the case can go forward without Waller's being a party to the case. That's not necessary. I think that the proper thing to have done was to remand the case.
But
And-
how does the district judge know that in denying a remand early in the case, you just said, well, there had not been any discovery when the judge, all I had was a declaration, but they didn't have the discovery. And as I understood your argument, you then took some discovery where it was learned that Mr. Wohlers had done other things that perhaps were actionable, and you could have either amended again to add him, to re-add him, or gone back to the judge and said, now we think that the facts were in error and this court does not have jurisdiction. But the district judge doesn't know what happens in discovery unless you file a motion or bring that to his or her attention.
And we did, Your Honor, under the intentional tort aspect of this case. In other words, we could have originally filed the case in federal court, and Wohlers would be an employee or was an employee of the company, and so his joinder wasn't absolutely necessary. And if the court agrees that in this particular case there's an issue of fact on both the statutory employment issue and a question of fact on the intentional tort, we still don't need Wohlers in this case. Wohlers would be a witness in this case because 3 of the employees have identified him as the one that gave the order. So he's not absolutely necessary for the case. We can go forward in the federal court without Wohlers being joined as a party. Now, I do believe that in the remand stage, that's the first time in my life where I ever prepared a 25-page petition in federal court. And I prepared it because the evidence that we were able to uncover in the early stages was overwhelming.
You agree that he has to have, and I know you have told us a couple times now that your complaint is very detailed about what he did. Do you agree that his actions have to go beyond the scope of his employment with the company? And otherwise, the company's your proper defendant, isn't it? And his negligence, if he did it in the scope of his employment, whatever his negligence may have been, the company is the proper party. Or do you not agree with that?
No, I do agree with that. And
He's got to do something outside of the scope or do something, as you say, an intentional act that's not within the realm of the company's mission.
I'm sorry, Your Honor.
Well, you mentioned the intentional act exclusion. I'm talking about liability. I'm still talking about the remand. For purposes of remand, he has to be a party for you to get the case remanded. So he's got to.
Yes, that's correct.
He's got to do something outside of what he would normally do in his agency capacity for the company.
Yes, and I think that I quoted Judge Drell, who observed in the Lafayette area or in the Acadiana area that many times a motion to remand is denied when in fact the case should be remanded. I believe some of the panel were Louisiana lawyers and trained in Louisiana law, and our statute 2315 is very, very broad. It is immensely broad. And so when we made the proper allegations in the petition for a reason, and I methodically set forth that Wohlers was a part of management. In his declaration, Wohlers admits that he was a part of management. And therefore, he was the one responsible for that recovery boiler. He knew that it needed to be drained because this was an annual shutdown. And he gave the orders not to drain it.
Let's take all of that as true. Let's just suppose that that is completely uncontested, that he did all of what you just said. That's not actionable at all without the application of the welding, which was the proximate cause of the explosion. But if there's no evidence that Walters knew that the undrained tank would be near enough to welding activity to cause an explosion or other danger, then he has done nothing wrong as a matter of civil liability.
Well, Your Honor, with due respect, I think that presents an issue for a jury. In the Reeves case, which I highlighted in the in the brief, the Reeves Court, which is a Louisiana Supreme Court case, literally says that there are some features that people will deny, and they are just not simply believable. And based on the experience that Waller had, and by the way, the Reeves case talks about experience. That's the whole point of Reeves. Waller's was not a rookie. Waller's had been there. He had been in the paper-making business since high school. He knew exactly what an annual shutdown was. And he gave the order, notwithstanding the fact that it hadn't been done in 28 years, he gave the order to drain the tanks. My point is simply this. With a annual shutdown, the tanks are drained for a reason. And they're drained for the reason that there can be welding anywhere.
Excuse me. Your time has expired now, and you've saved time for rebuttal. Thank you, Mr. Fazzio. Mr. Riggs?
Good morning, Your Honors. My name is Jeffrey Riggs, and I'm here with my colleague, Jennifer Michelle, on behalf of PCA. If I could, I would like to address a couple of things that were just brought up in the previous argument. And that is that what Mr. Fazzio is doing is he is bringing together facts that were, alleged facts that were determined later in deposition testimony and trying to use those to argue that the case should have been remanded. Of course, this court knows, as in Flagg, you have to look at the remand of what's before the court at the time the remand is being considered. And that's all the court could look at. And the court did it correctly. And some of the things that have been said quite...
That is certainly a general rule.
Yes.
But if you discover facts that you have no cause to have known before they came to your attention after the remand, and if they were in any way hidden, it seems to me that you would have had, that he could have asked for a reconsideration of the remand, notwithstanding the general rule of timing.
I believe that's possible, Your Honor, that someone can ask for reconsideration. Could also theoretically, since Mr. Wallace was dismissed without prejudice, could also theoretically move to amend and have him brought back in. So you could do either one of those things. He did none of those things. He did not ask for discovery at the remand stage. That was not requested. What was provided were the declarations, and the thing he's suggesting is at issue there, the kind of deceit, if you will, is not really at issue there at all, because he put in Ms. Partridge's declaration, which said that Mr. Wohlers made the decision not to drain the tank. So that was there. There's no big deal that later on Mr. Wohlers doesn't recall saying drain it down to 10 feet. He didn't. So there are two witnesses who said, yeah, we contacted him. Now this is after the fact, well after the remand. So I'm just addressing that point. But they said, yeah, we asked, are we going to drain the tank? And he said, no, we're not going to be working on the tank. There's no work being done on the stripper. Just take it down to 10 feet. That's what was said. So it's not really inconsistent. So I don't think there was anything hidden.
And he never asked for reconsideration.
That's true, Your Honor. So at any rate, on the remand, we believe the court properly exercised its discretion to pierce the pleadings. The plaintiff themselves offered a declaration as well as the CSB report, or it's actually a bulletin, to review. The court reviewed those, and I think the court correctly found that Mr. Wohlers could not be found individually liable because he had no actual duty, individual duty to the elite personnel that were doing the welding. He didn't know they were there. He didn't know, and that's very specific in his declaration, that he was unaware there was any welding being done in the area. He was unaware that the tank had gotten into an unsafe condition, and he was very unaware that there was actually, elite would actually be out there doing anything. Without that, I think the court properly determined that you couldn't have the link between what he did, if you accept it as true, that he said, I said drain the tank down to 10 feet. You accept that as true. That they can't make the link that he owed the elite employees a particular duty if he did not know they were there performing any work. And there was simply no evidence about that.
Is that it was routine. That it was, occurred every year with the shutdown.
But that's incorrect on a couple of fronts, Your Honor. On one front, that's not what's pled in the pleadings, okay? So back to, if we're looking at remand, that's not in there. An annual shutdown is exactly that. 1 year, or each year, they shut down the plant for a week and they perform various repairs in the plant. It doesn't mean there's going to be a repair on, in this case, a foul condensate tank or a clean condensate line. You don't know that. He didn't know that. But there are repairs done, but they don't drain all the tanks in this huge mill.
I heard out of the corner of my ear something about it had never been done in 28 years. I don't know what that meant.
That's what he says, and what he's talking about is this plant used to be owned by a different owner, and there was some testimony saying from the people that came on later, saying, yeah, we drained that tank each year. They did say that. Now, PCA had this plant for 4 years at the time of this incident. So that's 28 years is not really realistic, and Mr. Wohlers was a PCA employee, okay? So I think that just kind of misrepresents what the record was, particularly at the time the court was looking at the remand. And so I believe the court was they properly limited the review. It was very limited, made the decision to pierce the pleadings, made a proper review, and came to the correct decision. And the court found that Ms. Partridge's declaration did not overcome the uncontroverted facts as set out in Wohlers' declaration. And that is as it should be, and that aligns with Guillory. Similarly, when you have the declarant put up the controvert the allegations of the petition effectively and directly, then the court can determine that they were improperly joined. I'll move on to the other issues if you like. So the other two issues are on the contract issue. We believe the court also got that right, that in the contract there was a PO issued. The court found very distinctly the PO was issued by PCA to Elite, and that it incorporated on its face of the PO the terms and conditions found on PCA's website, and the court properly concluded that those were then integrated into the PO, and that the PO was accepted by the performance of Elite. Very clearly, very simply, basic contract law. You can accept a contract by performance, and the contract, the terms and conditions, explicitly incorporated the language we're all kind of used to seeing in the Louisiana Workers' Comp statute that set PCA, and quite frankly, as well as its subsidiaries, as the statutory employer of the Elite employees who were present. The third issue that I was going to address briefly is the intentional act exception. Without knowledge of the Elite workers being in the area, I don't know how you could ever say that anything Tim Wohlers did, he did with a substantial certainty that it was going to cause an explosion and injure these people. But aside from that, there is absolutely none, zero evidence that he believed that there was a danger, a hazard that was presented by taking the tank down to 10 feet? There's none. And there's particularly none that when he did that he would have had any belief that what he did was going to cause an explosion. There is just absolutely none. I'm happy to address that further, Your Honors, but that's pretty much it in a nutshell.
All right, thank you, Mr. Riggs.
Thank you, Your Honor.
Mr. Fazzio, you saved some time for rebuttal.
Yes. With regard to the statutory employment, we had two federal judges, Judge Shelley Dick in the Middle District, look at the exact same documents that Judge Kane in the Western District looked at. They got different interpretations. In Judge Shelley Dick's case, she interpreted that as not constituting statutory employment. Judge Kane, the only way that he could arrive at that conclusion is by reference. Now, the Louisiana lawyers know that we have very specific statutes dealing with statutory interpretation. A judge sitting as an Erie judge on this case would know what those statutes relate to and how they are applied. Judge Kane literally said at some point in his decision that statutory employment can occur by reference to a website. The word reference is not in the statute under consideration. Our Supreme Court has said more than once, you cannot, to lower courts, you cannot add words to a statute. So the idea that PCA can attach what they put on their website to a work order that Judge Dick said wasn't even signed by anyone, and draw the conclusion that in the Western District that this constitutes statutory employment is mind-boggling, because
That's why it's here.
yeah, I understand that, Your Honor, and thank you. But the point, the simple point is, we don't know, and we have to believe everything that PCA puts in their brief to associate these work orders with that particular event. It's not even the same date. It's dated in 2016, and the accident happens in 2017. So there was absolutely no question in my mind, and I hope in your mind, that this was a case that should go to a jury. And it should go to the jury on 2 points. Number one, statutory employment. Frankly, I think that if it goes to a jury, it's not going to end well for PCA. And the second reason, pardon me?
Why does that issue go to the jury? I thought your argument was a legal argument.
Well, my argument in my brief was both legal and the fact that it set an issue of fact that should go to the jury. Whether this was statutory employment or not is an issue of fact, just as it's an issue of fact about intentional tort. The one thing that PCA has never denied, we had an expert that looked at all of the evidence. They have never denied that they knew, because of their experience at Tomahawk, that the tank had to be drained or an explosion would occur. It has happened twice. And in the Higgins case, which I cite in my brief, that's the state of Louisiana law. You may get by with it on one instance, but if it happens again, and in Higgins was an explosion, then it should go to the jury on the issue of intentional tort and on the issue of statutory employment. Both of them are issues of fact. Thank you.
Yeah, thank you, Mr. Fazzio. Your case and all of today's cases are under submission. And the court is in recess until 9 o'clock tomorrow.